Thank you all for coming to this forum for the Rock County Circuit Court Judicial Candidate Forum. It's good to have an audience here, and if you have any questions, there are people out there with cards that you can write a question on, and we'll see if we can get it answered here. But we especially want to welcome our two candidates who are here to talk to us about their positions, Barb McCrory and Jack Hoag. So thank you very much for being here.
Thank you.
Thank you.
This is sponsored by the League of Women Voters, the Janesville chapter. The League is a national nonpartisan citizens organization whose work is to educate and register voters as well as to improve elections and government. Just a reminder that the Circuit Court general election will be held on April 3rd, and we do urge everyone to vote. The candidates were sent some questions posed by the League in writing prior to tonight. Their responses are posted already to those particular questions on the website for the Janesville chapter of the League of Women Voters. The forum tonight is being recorded, thanks to JATV for doing that. Information about rebroadcasting may be found on the Beloit and Janesville League chapter websites. This is the way the forum is going to work. Each candidate will give a 2-minute introduction, and then, as moderator, I will ask questions of the candidates, alternating who goes first. The League of Women Voters has prepared questions to use, and as I said, the audience may submit written questions on cards as well. Each candidate will have 2 minutes to answer each question. Our timekeepers, who are right there, will let you know when you're nearing the end of your time period by flipping you the 15-second card. And finally, at the end, there will be a 2-minute chance for each candidate to explain why voters should choose to elect you. So let's start with Barb McCrory, if you would like to introduce yourself.
First of all, I'd like to thank the League for sponsoring yet another forum. I think it is a great opportunity for people to hear from the candidates because there's so many elections that are going to be on the ballot in April. I'm Barbara McCrory. For the last 12.5 years, I've been a court commissioner here in Rock County. For the last 2 years, I've been a court commissioner in Jefferson County. And you may ask yourself, what's a court commissioner? I'm a judicial official. For the last 12.5 years, my job has been conducting hearings and making decisions that affect people's lives. And I think when it boils down to what the two of us bring to the race, Mr. Hoag brings a vast array of legal experience as a trial attorney, and I bring experience as a judicial officer, a person who does a lot of the same things that a judge does. A lot of my work is in the family law area. I've conducted, I think I looked at the numbers, and I did more than 1,300 hearings last year. And you may ask yourself, what does that mean? It means that people came into my courtroom with an issue that they needed to be resolved, and I'm the one that resolved it. One time it was whether or not a juvenile was going to be released from the juvenile detention facility because she had violated her rules just one too many times. Another time it may be whether or not I'm going to issue a domestic abuse restraining order. Is someone going to be held until we can do further work on a mental commitment hold? I also make decisions in regards to how much money are going to be coming in and out of someone's family, how much time people are going to spend with their children. I also spend time on the weekends for Jefferson County calling up and making sure that people who are arrested without a warrant, are they going to stay in jail until they can get in front of the judge on Monday? So I do a lot of different things in my role, but all of them boil down to one thing. I make the decisions, and I have to make them all the time. In addition to that, if you look at the lawyers in the Rock County, they thought that out of all of the people that were running, I was the most qualified out of all of them. And if you look at my reviews that I get from my judges on a regular basis, I get very positive reviews that I run my courtroom efficiently and effectively.
Thank you. Jack?
First of all, thanks to the League as well. I'm Jack Hoag. Some of you know me. I've been here for over 30 years. There is a major difference between the two candidates in the election, and that is our position on what judicial experience means. A family court commissioner does 3 things. They handle the initial hearing in a divorce, subject to the immediate review by the judge. They handle domestic abuse restraining orders, subject to immediate review by the judge. And they handle post-judgment custody and placement orders, subject to immediate review by the judge. Judges, on the other hand, do jury trials, criminal and civil cases, family law cases, They make the final decisions in family law cases. They handle termination of parental rights, and they do an array of work that the Rock County Family Court Commissioner does not do. I do all that work. I've done all that work for 30 years. When people in this town come with the most complicated matters, they come to me, and they have for 30 years. And that's why when I tell you that I believe I have the most experience, it's borne out by the facts, and it's borne out by the fact that that's what I've done. I've also been involved in the community. Some of you might know me from coaching your children or your grandchildren. I've been involved in teaching both at Craig and Parker. I've been involved doing judicial education at the judicial education conferences. I've been involved in my church, both as an instructor and as a volunteer. And I've been involved in the community and been a donator here at the public library, here in terms of the Janesville Youth Baseball Program, and a variety of different areas. I love this community. I've been a vital member of this community for years, and I'm good at what I do. And what I do is handle all the matters that a circuit court judge does. And so I think the decision is relatively easy and relatively clear. And when the facts come forward tonight, I'll be able to tell you more why I'm the most qualified candidate for the job.
I want to begin the questioning then with Jack. And I'll ask a question that's kind of a follow-up to what you just were talking about. Neither of you has practiced in all areas of the law. Sooner or later, you will have to decide a case involving issues unfamiliar to you. Other than reading briefs, how will you develop the background necessary to address those issues, either through research, consultation with other judges or lawyers, intense mediation, or otherwise?
Well, first of all, I'm not sure I agree with the premise of the question. All the areas that a Rock County Circuit Court judge normally handles, I have dealt with. That involves anything from small claims litigation, jury trial litigation, murder trials, and everything. So I'm not sure I agree with the premise. There will be times that issues will present themselves that maybe are novel for you, or maybe you've not heard of before. And in fact, there might even be positions that are being maintained that for the first time they're being considered. There are resources available for that. There are other judges in this community, all of whom I know, all of whom I deal with on a daily basis, that I feel I could rely upon and go to and say, well, what do you think about this? Because being a judge does not mean that you have all the knowledge in the world, and that you shouldn't reach out to others who've done these things before and consider what they might have to say. Being a judge is using your discretion and your talents to exercise discretion and determine, given a certain fact pattern and given the law, how do you interpret it in this case? Have you done this before? Have you written a special verdict in a civil case? Have you done these things? And that's why experience is so important. You have to make decisions on a momentary basis. Those are the same types of decisions lawyers make every day in trials and in the analysis of their cases. We have to analyze, does this fact get into evidence? Does this fact not? What facts do we need to build our case? Those are the things that you have to use and pour on experience. So you go to other people. You might also go to other people and just ask a person on the street, what do you think about a situation such as this? How do you feel about it? Now, that may not come into your decision as to what the law is, but I think community sentiment is also always something that a judge needs to be aware of. You have to be vigilant in ensuring that you don't become sort of somebody who always defers to what might be considered the public popular opinion. You have to maintain your contact with people and rely on your resources.
Thank you, Jack. And now we'll go to Barb. Would you like to answer the same question?
I'd like to start first with one of the things that Jack just talked about, and that has to do with, you know, if I have a novel issue, I might go up to someone on the street and ask them. Last time I looked, that's something that we can't do in the judicial branch. We have to maintain our impartiality, and we have to maintain being separate. We had a circuit court judge in Milwaukee County who was disciplined by the Judicial Commission for doing just that, asking someone who wasn't part of the judiciary for help on a case. We can't do that. We can rely on our other judges. Just this week, I had an issue come up in my courtroom, and I thought I knew the answer. So I went to Judge Dillon, and I said, you know, this is the situation that I had. What do you think? He didn't know the answer either. And so what does he do? He says, well, let's look and see what the case law says about this. That's what we do. When I first started out as a lawyer, the first training that I had was, all right, what does the statute say? And if the statute doesn't give you the answer, then you look and you see what the case law says. Those are the things that I've been doing. I always have novel issues that come into my courtroom that I'm going to have to deal with. And that's what I have to do. You start with the statute. What does the law say? If statute doesn't cover it, then what does the case law say? And then you go to other people. That's one of the reasons why I'm involved in judicial education on a regular basis, and I have been for the last 12 years. I do seminars and work with the judges to make sure that they're aware of what the new law is so that they can keep up with it and they can keep moving along. And that is what you do. You make sure that you know what's going on. That's why before I take any of my cases, I read the files before I go down so that I can identify issues. Today, I had to identify 4 separate issues to tell the lawyers where they hadn't done their work right before they could actually get into court. And so that's the other thing. You have to be prepared, looking at your files ahead of time so that when you get into court, you know what's going on and you can address those issues.
Thank you, Barb. And we'll start the next question with you. If you're elected, how will you work to reduce the racial and gender bias of the judicial system, of the advocates, and of the parties themselves?
First issue, I'm not sure that we have racial or gender bias within the Rock County court system. I think our judicial branch are people that work rather hard and maintain their integrity by doing that. But I can't help but say, when I was coming in here today, I looked on the wall, and it's Women's History Month. And there were things with Susan B. Anthony and Ida Wells. And I have to admit that it's Women's History Month, and if I'm elected, I would make history in Rock County because I'd be the first woman ever to sit as a judge. But that's not why I think you should vote for me. I think you should vote for me because I've got the judicial experience. I'm the one that makes the decisions. So how do I address it, though? I want to make sure that when people come into court, they have their say. They have the ability to give me their side of the story before I make a decision. And then it's what do the facts say and what does the law say, and that's how I apply it. But we have to make sure that we're also aware that there could be those biases out there, especially when we're dealing with juries. And I think at the last forum I discussed this. My husband had a case where he was representing a woman who was charged with sexually assaulting a child. And he was afraid that there was going to be some bias because she was a lesbian. And so he asked Judge Welker if he could do a private poll, no names attached to it, so that he could get the idea, what was the sense of that jury panel? And they were pretty surprised at some of the responses that came back and the bias that was there. So I think we always have to be vigilant and make sure that it's out, that we're aware that it could possibly be there, and think of good ways to address it. Thank you.
Thank you, Barb. And over to you, Jack.
Thank you. I think that's probably where the experience that Commissioner McCrory had just isn't significant enough to be aware of the issue. One who practices in all areas of law and deals with juries and has dealt with juries for over 30 years, the notion that gender or racial bias is not present at some point in a courtroom probably is naive. It exists. Does it exist as much now as it did 30 years ago? No. Is it something that we combat on a daily basis? Absolutely. It's something that you have to be vigilant about, that we agree upon. But the notion that you'll get 12 people on a jury to come into a courtroom and be able to separate all of their past from the decision that they have to make, I hate to report this to you, but it's very difficult for people to do. And that's the goal of the lawyer. That's the goal of the lawyer, to ensure that the panel is as pure as it can be and making the decisions based on the facts of the case and the judge applying the law that needs to be applied. So as a judge, when voir dire is conducted of a jury, a judge has the right to interject questions. And one of the questions I've always asked jurors, I've said, tell me, truthfully now, if you're walking down the street late on a Friday night and there's a black man walking on the other side, on your side of the street, you going to switch to the other side? Because if you are, I'm not going to embarrass you in front of all these people, but I want you to raise your hand when you say that you're not sure that you can decide this case based on the facts presented to you and the law that the court gives to you. A judge can interject that in voir dire. I've had it happen. I've had judges throughout the state and the federal courts that I've practiced in for sometimes say, I'm going to take the lawyer's question just a little farther. That's what I would hope that I would do. The importance of that is we have to build a community that is racially and gender bias free. And that's what I hope I would contribute as a judge.
Thank you, Jack. And now I'd like to ask you the next question. Judicial elections in Wisconsin are nonpartisan. During this campaign, have you accepted any form of help from anyone acting on behalf of or connected to a political organization?
I have not, nor would I. I'm afraid to report to you that you'd be surprised how many times in the nonpartisan election you're asked, are you a Democrat or Republican? Are you a conservative or a liberal? I quite honestly object to those labels being placed on people in general terms. We live in a society now where you see it every night on TV. Somebody says, well, she's a conservative, or he's a liberal. That's not what this election is about. This election is about applying the law, the willingness to apply the law and do it in a way that exercises discretion in a meaningful, educated way, without reference to political party. It does not matter what political party you belong to, if you've even ever belonged to one. The purpose of a nonpartisan election, and I know right now in Wisconsin, this is a difficult thing because we are in a very heated political environment. But this is a nonpartisan election, and partisan politics have no place in this election. And for somebody to assert that they do is wrong, and you shouldn't pay any attention to that. Because how do people know? How do people really know how you are, what your political views are? Has anybody bothered to ask us? No. Well, they have, but we can't give the answer because it's nonpartisan. And so I hope that everybody, when it comes to that point in deciding who to vote for, recognizes that and recognizes that there's a reason for that, and that is we have laws, and laws have to be interpreted by judges, and they have to do that without reference to political beliefs, and they have to do it in a time right now which is a politically charged time.
Because I've been a court commissioner for the last 12 and a half years, I've been under the rules of judicial ethics, and I have not been able to be involved in politics, partisan politics at all. And that's something that I take very seriously, to the point where I don't even sign nomination papers for partisan officers, because I don't think it's appropriate. Why? Because the judicial branch is an independent branch of government, and we cannot be involved in the partisan nature of the things that go on. Mr. Hoag is right. What we have to do is follow the law, and the law is nonpartisan as well. The other problem is that in the judicial branch, we are an independent branch of government, but unlike the executive and unlike the legislative, we can't tax people to fund ourselves. We rely on the legislature and the executive branch for our funding. So if we start getting involved in partisan politics, it's also going to ruin the opportunity that the court has to operate. Because if we start getting involved in that area, then we're going to have the legislature or the executive saying, we don't want to fund the courts, or we're going to take this away because we don't like it. Being a judicial officer is a pretty lonely thing, because you have to be independent, you have to be impartial, and you can't rely on other people to help you make those decisions. And so we have to keep that independence. And so I have not accepted any help from any partisan organizations, nor would I, because it is not appropriate. And I have not been involved in partisan politics for the last 12 and a half years, because it's not appropriate for me to do so. Thank you.
Thank you, Barb. And the next question is yours, and this is somewhat connected to the question that you just dealt with. In light of recent refusals by state judges to recuse themselves, when there is a perception of conflict of interest or undue influence, do you believe the current system for overseeing and disciplining judges is effective? If not, please explain how it could be improved.
I had that same question asked of me today when I was down in Beloit, and it's going to have to start at the top. The Supreme Court is the organization that sets up the Judicial Commission, and the Judicial Commission is then the organization that actually goes through and decides when it is they're going to file complaints and then take action against people. I'm looking forward to getting some answers to some of the questions that have been raised. I think it's going to be appropriate to find out, is it appropriate for a trial judge to sign the recall petition, or is that getting involved in partisan politics? As I said, I haven't done that, so we're going to need some direction on that, because there's not a lot out there. How would you change it? I'm not sure, because the other problem is that making it, you'd want to try to make it more open, but in doing that, you're going to have to get the right sort of people that are going to maintain the confidences that need to be maintained. The way the Judicial Commission works at this point is everything that they do is confidential until it gets out in the open and they're going to be actually filing grievances against someone. That's something that I think we need to, but it starts at the top. It starts with the Supreme Court, and they're going to have to make changes to their rules before we get down to what we're going to be doing.
Thank you, Barb. And Jack, over to you.
That's a loaded question if I've ever heard it, given what's going on in our state right now. We have, unfortunately, right now in our state, a judge who's accused of strangling another judge in her chambers who was not charged criminally. If one were to poll the lawyers that practice in the area of criminal litigation, they would tell you that, generally speaking, a situation like that would result in criminal charges. So when we say, how do we improve the judicial discipline system, quite honestly, we have to implement the laws that we have right now. We also have a judge who supposedly decides cases while accepting fees from one of the firms involved in the case. Now, I understand that that same court oversees the lawyers, so you are at somewhat peril. But if you were to ask lawyers, generally speaking, in Wisconsin now, how they feel, they would probably tell you they're embarrassed. What's going on right now is wrong. It's not judicial-like, and it is a system that needs to be examined and needs to be considered. It's not the role of a trial court judge, and I don't pretend to be smart enough to be able to tell you how that system needs to be overhauled. What I will tell you needs to be overhauled is the behavior. The behavior is atrocious. It can't be condoned under any circumstance, under any condition. I understand we don't have all the facts. I understand that those facts need to be developed. But quite honestly, it is embarrassing.
Thank you, Jack. And the next question is for you to begin with. What are your views on current criminal sentencing guidelines in Wisconsin?
And that's for me? Thank
Yes.
you. Well, we have federal court guidelines. Quite honestly, I'm not a big fan of them. There's been a recent, many of you probably are familiar with those, but when they were passed, there was a great disparity between crack sentences and cocaine sentences, both the same drug essentially, but crack is used by persons who are, generally speaking, poor, generally speaking, black, and those sentences were much more harsh than the cocaine sentences. So I'm not a big fan of those guidelines, but there have been changes in those lately. Our courts, the circuit courts of Rock County, have guidelines might be a little too strict a term to use. And that's probably one of the things that I think a judge is most important for. Judges here in Wisconsin, trial courts, are really allowed to use discretion. They know what the maximum penalties involved in certain cases are. They know what the lawyers are recommending. They have some idea of the history of what's gone on in the courts before dealing with these various crimes. And they have to formulate sentences. And they come up with sentences that sometimes might seem to the general public to be either random or might be not as severe as they should be. But I think then we have to examine the basic premise. Does incarceration necessarily, in all cases, improve the result? And the result we obviously want is stop the behavior. Minnesota, right now, has an incarceration rate of less than half of Wisconsin. Now, there are certain sentences that need to be harsh. They need to be jail sentences. But there are also other cases where there are alternatives to incarceration that need to be explored. Minnesota has done that more than we have. So to answer your question, we don't really have guidelines. We have principles that judges sentence upon: deterrence, punishment, and protection of the public, and they have to be balanced by judges, and that's the role of our judges in the criminal courts.
Thank you, Jack. Barb?
The whole idea behind having guidelines in sentencing comes from a desire to make sure that, if you've got someone who's committed similar crimes, that you've got some sort of consistency in what the punishment is going to be. But as Mr. Hoag said, and I agree with him on that, that takes away the discretion that the trial court should have in every situation. And so the guidelines really sometimes do pin you into circumstances that you might not necessarily think are appropriate in a given situation. And so I think at this point, because we don't have the strong guidelines, they talk about some of the sentencing guidelines in terms of the drunk driving that go around within the district to make sure that that's there. That's so there's some sort of consistency. But it does take away the judge's discretion. And when it comes time for sentencing, that's, I think, when you do need that discretion, and that's why you elect a judge. You elect us because you think that we've got the ability to exercise that discretion and that you trust that we're going to be protecting the public interest when we make those sentences. And so that's where when you talk about this issue, it's appropriate, I think, with the way we deal with it, to have that discretion with the trial courts. And what we do in sentencing, first and foremost, is making sure that the public interest is being looked out for, making sure that the punishment is going to fit the crime and the circumstances behind there. And when you start having the guidelines, that goes out the window, and you're taking away that discretion.
Thank you, Barb. And you won the option of answering the next question first. Judges have to make decisions according to the law without regard to the power, wealth, or standing of a litigant. Please describe a time in your life when you told an unwelcome truth to power, that is, to a person or a group in a power position.
I have to admit that I probably do that on a daily basis, because in any relationship there's imbalance of power within those relationships, and so I have to do that. I can't think of any specific situation, but there are times when I've had one of the parties that makes a whole lot more money than the other party in a divorce, and I've had to say, well, you're going to be paying this or you're going to be paying that. In domestic abuse restraining orders, where there's a huge disparity in the power, I will look at the person who is there, who's the respondent, and I will say, you are not going to have any more contact with this person. And that's a disparity. So that's the sort of stuff that I have to do. I have to look at the facts as they come in front of me, and I don't care other than that. They have to come in front of me, and I have to give them that decision. And that's what I do. And it's not easy. It's not easy at all to look someone in the face and tell them, this is the way it's going to be. You can't reach an agreement. You've done something wrong. Telling that teenager when she was crying and saying all she wanted to do was go home, but her actions didn't say that because she'd broken the rules one too many times. And I said, no, you're not going to go home at this time. So I have to do that. And that's part of what a judge does. It takes a while to get to that point. I've been doing it for the last 12 and a half years, and it takes a while to get to that point where you feel comfortable doing it, and you know how it is you're going to go about making your decision process.
Thank you, Barb. Jack?
Well, in the context of somebody who's done an aspect of practice has been criminal law, I probably do that. I can't even tell you how many times over the years. As you know, in our country, race relations has oftentimes been things that have been spoken about, but only behind closed doors. I've actually had to go to officials and say, look, if this person was white, you wouldn't be charging him with this. Or if this person was a woman, you wouldn't be charging him with this person with this. I actually have to do that on a daily basis. Now, does it take some ability to deal with people? It does. Those are things that a lot of people, nobody wants to be called a racist. Nobody wants to be called a woman hater or a man hater. So are there ways that you have to present it that are effective? There are. But as I said earlier, if you think that we're at a point in our country where everybody's treated uniformly, I'm afraid that's not the case. And do I have to go in the offices of powerful people and say that? I do. Do I have to go before judges that are powerful and try to figure out a way to say that in a way which is effective yet not offending? I do, and I have. So, quite honestly, I do it on a daily basis. That's not to say that it happens all the time. That's not to say we haven't made tremendous progress as a society and a legal system in dealing with that. But those are things I've had to do daily, not just in one aspect of the law, but in all aspects of the law. I have to go into courtrooms and take unpopular positions many times. And probably in the election it's going to end up hurting me. Somebody's going to say, well, you argue for that, you're an idiot. But that's what is required of advocacy, and that's what I've had to do. Thank you.
Thank you, Jack. And so you're first for the next question. Every judge develops a reputation as to the pace at which matters move from commencement to conclusion in their court. Some judges insist that cases move along rapidly and allow a continuance only in extreme circumstances. Others are willing to allow counsel to set the pace of litigation and are reluctant to exert pressure to accelerate the process. What will be your policy in setting the pace at which litigation proceeds in your court?
I've been asked this before, and I'll tell you quite honestly. I believe, as with everything else that we do in life, communication is the key. I believe that the overwhelming majority of lawyers are trying to do the right thing, and so I'll consult with them. And my position will be, look, here's what I'm going to tell you. You tell me how much time you need to get ready for trial. Once you tell me, though, I want you to know I'm going to expect that trial to go forward then, absent some compelling circumstance. Those things happen. Your expert witness can't get had a death in the family. Another key witness did. Don't get me wrong. But I think you have to do it in collaboration with the lawyers. You have to let the lawyers exercise their craft. Almost all of them really do want to move matters forward. Now, as a judge, you have to have the discretion to realize when you're being stalled because that's what the client wants. But again, you handle that through communication. You say, okay, guys, here's how we're at. I want to know how much time you need. I want you to I'm going to bring you back here in 2 months. I'm going to have you tell me where you're at progress-wise. And then there'll be no excuses 4 months from now, absent some compelling circumstance. So my belief is communication with the lawyers, letting the lawyers perform their art, making sure that you have sort of checkbacks to make sure it's going on. And yet, you can't have a hard and fast rule that says, I'm sorry, you have to miss your high school, your son's high school graduation, or you can't miss your son's graduation from Harvard, you have to miss that. I don't think that's the way to do it either. But I do think that there is a way through communication with lawyers to make sure that they're moving their case forward. And again, that can be done through advanced pretrial planning. Some of the judges do that already. Most of them actually try to do that. But I think it could be improved even from what we're doing right now.
Thank you, Jack. Over to you, Barb.
That's how I deal with people when they come into my courtroom, when I have to schedule hearings. I first ask, all right, how much time is it going to take you to get ready for your trial? What else do you have going on? And then we work towards it and we get things scheduled. I think one of the things that I am the most frustrated with in my job is when the lawyers tell me, okay, yep, we'll get this scheduled. I block off a time. I block off a half of my day to hear a case, and then they show up and they're not ready. Or they show up and they say, oh, well, I thought we were only here for an hour, and I've got something else scheduled over here. And they make people wait. That's where I get a little bit frustrated. When they actually tell me that they're ready, we're going to go, and then they don't show up. And then you leave everyone else sitting there waiting. I've recently heard of a situation where there was supposed to be a sentencing that was supposed to occur at 8:30 in the morning. The victim was there, ready to go, but the lawyer had something else come up. So they were going to reschedule it, and it was going to be at 1 o'clock that afternoon. So the victim shows up at 1 o'clock. The lawyer's late again and shows up at 1:30. We need to make sure that we hold some accountability to lawyers. When they say they're ready, absent something going wrong, they're going to do it. And I do know communication is the key to that. In Jefferson County, one of the things that I do is I do pretrial all pending divorces. I sit down and I meet with the parties, whether they're pro se or they have lawyers. We figure out what we need to do in order to get the case ready to get to the judge, so that when it gets to the judge, he can say, all right, we're going to put this on for a trial in a month, and they're ready to go. So I have to work through with them, and there is that communication. What do you need us to do? What orders do you need? What discovery do you need? What do you need to get done? But once you get something done, I want to make sure that we get things started on time and that we get things moving, and not have these delays, because the other side's there and ready to go. And it's a little bit frustrating for them, and so I want to make sure that we also keep things moving.
Thank you, Barb. And you're up next for this next question. If you could write one perceived injustice in the Rock County court system, what would it be and why?
I think I get these questions that I'm not, it seems like that's a tough one. Perceived injustice in the Rock County court system. I think one of the areas where we need to work on is, and this is more in the criminal area, has to do with the long calendar calls that take place where people sit around and wait for a very long time. And they wait and they wait, and there are endless cases coming through. There's got to be a better way to do it. I'm not sure I know what that is. I look at what other counties do and how they handle it with pre-trialing with the DAs before they actually get in front of the judge. And so that might be one area to look at. I do think that sometimes people do get frustrated with that, and that's something that we would need to work on in figuring out a better way to deal with it. As I said, I don't have the answer for that at this point, but that might be one thing, people waiting.
Thank you, Barb. Jack?
Well, I would probably focus on that a little bit too. We're in a different age. We're in a much different age in terms of the number of actions that are filed, the resources available to deal with them. Our court system is handling way more cases than we've ever handled before. Lawyers are being asked to do things now that they've never been asked to do before. Respond to faxes, respond to text messages, respond to emails, respond to phone calls. And so I understand the notion that perhaps people think there's a lot of downtime in court. I will tell you, the downtime in court now, as opposed to back years ago when I used to go down to Beloit, is minuscule compared to that. When you used to go down to Beloit for a Monday morning call, you'd be down there all morning. You don't have that happen anymore. The judges make an effort to get cases through. So I would say one of the perceived injustices is the accusation that they're not moving cases through. I will tell you, I've practiced in a lot of different counties. One area that we could do better, quite honestly, is in Jefferson County. The district attorney's office in Jefferson County has on its table in the courtroom a computer that's mainlined into their main office computer. So when the judge says, well, this is a case that belongs to Mr. Smith in your office, is he available that week? They can look and they can tell you. Walworth County does the same. I think that's a good practice. That's one perceived injustice. Another perceived injustice I haven't liked, quite honestly, is in the course of this election, the bad-mouthing of some judge that's leaving office. I don't think that's appropriate. I think that he's been, I've heard it by other people, saying things that really aren't deserved. Judge Welker's done a good job for years. You may not like his presentation sometime, but quite honestly, he was never afraid to make a decision, and he would always make it if asked. So if there was another perceived injustice, I would say that is the second one. Thank you.
Thank you, Jack. And now I'm going to start with you for the next question. If you became aware of unethical conduct on the part of a trial advocate in a case in which you were presiding, how would you address it?
Well, a couple things. Number one is I don't think that happens very often, very rarely. But if it did happen, I am big on, number one, there's no need to embarrass people. So you maybe bring them in chambers, both counsel, and you say, okay, this is what I saw out there. Will you tell me your position on what I saw? Tell me, am I seeing it wrong? Did something happen that I have the wrong message of? And give them an opportunity to correct the mistake, and give them an opportunity to explain it. Both counsel would be present. It would be impartial. Both people would have input into the position, and I'd want to know what happened, and give that attorney an opportunity to explain that. Quite honestly, the question is based upon a premise that really doesn't happen. You don't see things in the courtroom like that. They don't happen. They haven't happened. Have they ever happened? Sure, they've happened. But most of the time what it is, sometimes advocates get zealous in their advocacy. The Code of Professional Responsibility says you have to be a zealous advocate. So when you're zealous, sometimes that line might be bumped up against, and giving the attorney an opportunity to come into chambers, take a deep breath, say, slow down, what happened out there, tell me what happened, is probably the way that I would address that.
Thank you, Jack. Barb?
I did have to deal with this issue as a court commissioner. We had a post-judgment motion having to do with the placement issue. And the attorney, after the lunch break, said, Your Honor, we need to talk. During the morning, he had put on perjured testimony. 2 men had come in to testify on behalf of the mother about their relationships with her and what was happening. Unfortunately for this poor lawyer, he didn't know it. And so he said, we need to talk. And so we got the other attorney and the guardian ad litem, and we went into my office, and he laid it out for me. He said, at the time, I didn't know this was perjured testimony, and I believe him. and I believed him at that time. And so what we did is we went back into the courtroom, and he said, I need to withdraw because this is what happened. We were 3/4 of the way done with this hearing. He had not done anything wrong. The woman admitted that was what had happened. She said, I don't want him to withdraw as my attorney. We want to get this done. And so I didn't let him withdraw, and we finished it. But that's how I handled it. He did raise the issue. I knew it was coming because the way the attorney was asking, the other attorney was asking the questions in the morning, and I come back from my lunch break, and there is a video recorder in the television. I'm like, he had her under surveillance. And the attorney didn't know, and he raised it with me. And had he not, had we had that information, then I would have had to pull them back in and say, did you know that this was happening? But he did bring it forward, and that's how I handled it, because I do need to do that.
Thank you very much. I think that we've asked a great many questions of you, and I think at this point we'll come to a close. You will each have a 2-minute chance to explain to voters why they should elect you. And I think we'll start with Jack, because you just finished.
Thank you. The reason you should elect me is that in a judicial, nonpartisan election, what you look at is the experience of the candidate, and has he handled all the different areas of law, and what experiences he had in critical situations. If you look at those facts, and I'm not asking you to do anything other than look at the facts, break it down. Since the year 2002, when CCAP was formed, I've handled over 1,500 felonies, over 1,400 misdemeanors, over 1,000 family law cases, almost 300 civil cases. I didn't even go through the small claims and so forth. My opponents never handled a criminal case, either felony or criminal, or felony or misdemeanor. Handled 8 civil cases, and this is before the advent of her job as a commissioner. While as a commissioner, based on the 2011 new court filings, family court filings are less than 5% of the work that is done in the court system. I've handled 100% of it. So in terms of the experience, it's a very clear and definite choice. Then you have to ask yourself, and go out and ask. Ask the people in the courthouse. Ask the judges, what are the reputations for integrity? Does either one say things that's not supported by the evidence? Have they run a campaign that says things that's not supported by facts? Ask those questions. Because what you're looking for is somebody who's impartial, who uses the facts, and decides it based upon the law. Ask people, have they entrusted a person with their children to take them throughout the state, coach them, be with them? Ask them, who do you trust? Do you trust this candidate? Do you believe that they'll make a decision based upon the law and the facts that are given to them? I think when you do all of that, when you do your research, and please do your research, don't base it upon what you hear simply because it's said. Do your research. And if you do that, you'll see the choice is clear, and you'll vote for Jack Hoag. I hope you do that. I hope you do your research, and I'm convinced if you do, that's what will happen. Thank you.
Thank you, Jack. And now, Barb, it's your chance to explain to us why we should vote for you.
I think you've seen with Mr. Hoag that he is a very good litigator. He takes those facts that are important for his case and he talks about them. What he fails to say when he's talking about those CCAP filings is, I stopped being a lawyer and representing people in 1998. I've been a court commissioner since 1999. He talks about handling 1,500 felony cases. Last year, I handled 1,300 hearings, meaning I had to look at the files, I had to know what was going on, and I made the decisions. I told you some of those decisions that I had to make. So when you're talking about experience, you have to ask yourself, what is the important experience? There are very few lawyers are going to be able to come in and know everything that's going on in all aspects of the law. It just doesn't happen. Judge Daley, when he asked me to be a family court commissioner, when he came on the bench, he'd been a district attorney, and that's where his concentration had been. Judge Fitzpatrick, when he first took the bench, had had no criminal experience, and that was where he was. And what did he do? He learned what he had to do, because that's what we have to do. We're never going to know all of the situations that come in front of us. So you have to ask yourself, who makes impartial decisions? I make impartial decisions every single day. Who looks at the law and applies the facts? I look at the law and I apply the facts every single day. When you ask the judges who is important, or not who's important, but when you ask them, what sort of work do I do? Judge Bates, in my annual reviews on a regular basis, says that I handle the people in my courtroom that are very emotional. I handle them well. I move cases along effectively, and I make those decisions to keep things going. Judge Koshnick up in Jefferson County says the same things about me. When I do my judicial education, I always get very good reviews for understanding what's going on and being able to give people a good decision. So when it boils down to who has the experience, I have that experience in making those decisions. And I think that's clear, and I hope you'll vote for me come April 3rd. Thank you.
Thank you, Barb. On behalf of the League of Women Voters, we thank you both for coming to this forum and for sharing with us your thoughts on the questions that we asked you. And we thank you, audience, for being here. And I want to remind you all that April 3rd is the day to be out there voting. So thank you very much.
Thank you.